There's Chris. Chris, I recognize that necktie.
Chris, you were muted while you were talking there, I think.
That's right. You can hear me, Mike? Perfect. Perfect.
Do we have Dean Buzang? She's supposed to start things off.
I do not see her. I'm going to send an email to Lori just asking.
Yeah.
Oh, wait. There's, yes, I am here. I see a chat from her.
Okay, good.
Dean, do you want to test your mic? Oh, it says, can someone turn on my mic and camera? Pearl? Pearl, can you hear me?
Am I unmuted?
You are unmuted.
You are.
Welcome. Thank you for doing this.
Okay. Can you hear me?
You're fine.
Can you, I suspect you can't see me. My camera says it's on. And so
Do
if
you,
you
do you have a cover over your camera lens by any chance?
no. I've been on camera all day.
Do you want to log out and maybe try logging back in?
Well, another option, because you're 4 minutes off schedule, is that somebody else do the welcome, because I do not want to be your problem in launching this program. So does somebody else have the welcome remarks and they can just do it?
Dean, why don't you do it and just do it by audio if that's all right?
Yes, thank you. Do you want me to start now? Tell me when to start.
We've got just about everybody, so let's get started.
Good afternoon and welcome. My name is Kathleen Buzang, and I'm the very proud Dean of Seton Hall Law School. Obviously, we're having some visual problems today, so please forgive my voice sans camera. It's my honor to welcome you to a very special program that Seton Hall Law has organized with the American College of Coverage Counsel to help our law school community and other interested parties to gain a better understanding of the wave of COVID-19 insurance coverage litigation that has enveloped our courts since this pandemic was first recognized just about a year ago. Briefly, let me just talk a little bit about Seton Hall Law School. We're open. The students have the option of attending classes in person or remotely, and the 1L class in particular is overwhelmingly attending in person. The building has been entirely retrofitted to keep us all safe. And as far as we know, not a single person has been infected as a result of attending classes. Our graduates took the bar remotely in October, and Seton Hall Law graduates sustained our record of exceeding the bar pass rate by over 10 points. The class of 2020 is 95% employed, so I thank the many of you who hired our graduates. The class of 2021 is on the market, so if you're looking to hire, please let us know. For those of you who are not familiar with the American College of Coverage Counsel, the ACCC is a nonprofit association of 400 peer-reviewed lawyers who represent both insurance and policyholders. Its mission is to improve scholarship and professionalism in the resolution of insurance coverage and bad faith disputes. Today's program is one of a series of webinars that the ACCC has created with leading law schools around the country to educate clients and colleagues about the COVID-19 insurance coverage litigation. Since the first COVID-19 insurance suit was filed in New Orleans in March 2020, over 1,700 lawsuits and class actions have been filed against insurers in every state in the country. There has never been a catastrophe that has generated such widespread litigation so quickly. Nearly all of the cases that have been filed so far concern efforts by policyholders to obtain business interruption coverage for lost income during this pandemic. And it's also highly foreseeable that other types of insurance disputes will arise in the near future as new types of lawsuits are filed against corporate policyholders for liabilities arising out of this pandemic. Today's program will include panelists discussing possible claims involving directors and officers, employment practices, and general liability insurance policies to give you a preview of what those disputes may look like in the future. Given the size of the audience for today's program, it isn't practical to let you ask questions of our panelists live. Accordingly, we ask that you save your questions for the time that has been reserved for the end of the program. Meanwhile, please feel free to post any comments or questions through the chat function during the course of the afternoon. So let's start with our first panelist, who's Michael F. Aylward of Boston, who will provide us with an overview of how the COVID insurance litigation has evolved over the past year. Michael is a senior partner in the Boston office of Morrison Mahoney, where he chairs the firm's complex claims practice group. Michael is the immediate past president of the ACCC and has spearheaded its response to the COVID-19 crisis, in which he is local and national counsel for several insurers. Michael?
Thank you, Dean Buzang, and thank you, Seton Hall Law School, for helping us organize this program. This is one of a series of webinars that we've been doing over the last 8 months as the COVID litigation has evolved and it's, frankly, as you'll see today, changed dramatically. My job is to set the table. In the next 10 minutes, I'm going to try and give you a history in literally 9.5 minutes of how this litigation has gone from a single case in Louisiana to the largest single set of insurance coverage disputes I've ever seen in my lifetime, or ever hope to see again in my lifetime. But let's get started. This is always the exciting part. So this started literally 11 months ago in New Orleans with the Oceana restaurant litigation, and it exploded. This is the time when state after state were passing or enacting new closure orders that had a dramatic impact on businesses, particularly restaurants. In the succeeding 11 months, the litigation has gone crazy. I mean, there literally are over 1,500 different lawsuits in nearly every state. About a third of those are class action cases. And that's a quick track of how this has evolved. For the most part, the litigation is in a handful of states, even though, like the pandemic itself, it's spread across the country. The jurisdictions where the litigation is most intense are Pennsylvania, Florida, California, Ohio, New Jersey, and Illinois. Pennsylvania is somewhat skewed because there was a tremendous effort to get the multi-district litigation situated there, where plaintiffs' firms were trolling for clients for weeks and weeks. But it's certainly one of the most intense. The ones that are really active, though, are California, Florida, Ohio, and Texas. Not all states are created equal. If you represent insurers, you want to be in federal court in California, Florida, or Texas. And conversely, if you're a policyholder counsel, you want state court in the Western, in Missouri or Ohio. The cases in federal court, so far at least, are turning dramatically in favor of the insurers, such that policyholders are making great efforts to remand these cases, either by adding state actors like mayors or governors, or with greater success in states like Pennsylvania, arguing that the federal DJ Act doesn't give discretion in cases where state law is unclear, and that these should be decided by state judges, not federal judges. As Dean Buzang indicated, most of what we're dealing so far is not only first party, but commercial property disputes. It's likely, however, that this will evolve over time, just as the way the cases are being litigated has changed. Let me walk you through what I see as the different phases. This started 11 months ago with what we call the little fish, the restaurants, the beauty parlors. And the lawyers filing these cases were not people most of us had heard of. My supposition is that the large firms that tend to represent Fortune 500 companies didn't represent restaurants for the most part, or were quoting rates that these small businesses couldn't afford and wouldn't do on a contingent basis involved. And these were the national class action lawyers. Not coverage people, but skilled in suing banks and other financial institutions in class action claims for consumer protection damages. And their goal was consolidation. They immediately, within weeks, filed 2 or 3 different petitions with the multi-district litigation panel arguing that these should all be consolidated in one proceeding. There was intense briefing, and ironically, for the most part, policyholders joined with insurers in opposing this. And on August 12th, the JPMDL denied the applications on the basis that this really would not benefit from consolidation. It was too big, too complicated, and too many different issues and parties. The JPMDL did allow consolidation later on insurer-specific MDLs in limited cases, not with the big PNC companies like Travelers and the Hartford, but with small regional companies like Society or Erie Insurance, where there were common policy forms, only a few state laws at issue, and enough claims that consolidation would make these cases more manageable. There are also efforts to consolidate in individual districts and state courts, notably in Pennsylvania. The real issue is going to be, will these cases survive early dispositive motions such that discovery will occur that would benefit from coordination? While the MDL was pending, a lot of early 12b6 motions backed up because the federal district judges didn't want to decide cases if they were about to lose jurisdiction over. Those motions started to get decided. And since Labor Day, there were 1 or 2 and now a flood of rulings. We are literally getting 10 or 15 a week. That's the track. You can see right around early September where it just starts to take off, and it's just skyrocketed ever since. In response, in recent months, policyholders have come up with their own tactic, not a 12b6, but early motions for summary judgment. This largely came out of a decision in North Carolina where a state judge granted summary judgment to a policyholder, and it was a way of sort of pushing back against the 12b6 practice that we're now seeing in a lot of different states. For the most part, carriers are winning. They're particularly winning in cases with virus exclusions, overwhelmingly in federal court. In cases where there isn't a virus exclusion, not so much. And in state court, it's a real mixed bag. I mean, again, if you're a policyholder, you really want to be in state court. You can see the difference in terms of the number of rulings, the light blue that carriers are winning, and the dark where policyholders are succeeding. There had been a number of cases, particularly in Ohio, states are being denied. Those cases are going to go to trial at some point. In fact, the first case that was filed in New Orleans, the Cajun Conti case, was tried to a judge in January and February. And there will be interesting issues in terms of what sort of discovery. Meanwhile, we have over 100 decided opinions already, and a lot of those are going up. In fact, almost all of them are up on appeal, particularly in the federal circuits for the 3rd, 8th, and 9th Circuit, as well as state courts in North Carolina, the District of Columbia, and California. So far, the Supreme Courts in those states have resisted efforts to accelerate their involvement. They want to wait for these cases to move through the intermediate appellate courts before they look at them. The new phase that we're in are what I call the big fish. We had the minnows, we had the sharks, and now we've got the tarpon and the tuna. Early on, these were small businesses, restaurants, hair salons, exercise facilities. Now we're seeing the Fortune 500 companies. These are companies that took a while to figure out what their losses were, wanted to give some thought to what they had to do, didn't have the sense of desperation that small businesses had. And there was also, I think, some sense that the little fish were screwing up the law. And it was time for the big boys to get involved in litigation. And that's certainly what we've seen in recent weeks, in recent months. More and more of these cases are being filed by entertainment conglomerates, hotel chains, sports teams, and the lawyers that are representing them are the kind of firms that are actually involved in our American College of Coverage Counsel. They're the firms that have handled complex insurance litigation over the years. We're actually seeing a lot of the little fish drop out. I've had quite a few cases, as have most of my colleagues, where in response to 12b6 motions, someday the law will get better. There's also a hybrid kind of litigation where similar kinds of insureds have banded together with one law firm and one lawsuit in a way of maintaining, sort of sharing the cost of litigation. So where is this going at this point? There was serious concern on the part of the insurance industry last year that there was just going to be no end to this, that conceivably every business in America might become a plaintiff. That seems to be not as great a concern as was originally imagined. And in fact, we've recently seen a significant drop in new filings. I think the class action lawyers, since the MDL went down the tubes, don't see this as a cash cow. And as I indicated, the smaller fish just don't want to stand for the long haul on this. But that's the track that we've seen. I mean, you can see where it surged during the summer and really has dropped off in recent weeks. I would suggest that the early cases may, although they're really overwhelmingly in favor of the insurance industry, may not be reliable for the long term. The lawyers who represented the carriers in those cases were better, more experienced, and better able to seize the initiative. And the sheer number of federal rulings in particular created a bit of a snowball effect where it was easy for other federal judges to follow suit. There have been a number of recent decisions in Pennsylvania, for instance, that create a counter narrative that if a judge wants to find coverage or doesn't want to dispose of a case early on, has a credible basis for taking a position allowing the case to go forward. Ultimately, this is going to come down to state Supreme Courts. I mean, those of us who were in the pollution wars in the 80s and 90s, and more recently coverage B fights and Y2K and things like that, it ultimately comes down to state law and state Supreme Courts. So the insurers have won the opening battle, but frankly, the outcome of the war is still uncertain. It's my pleasure now to introduce our next panelist as we get into the meat of the issues. The key issues on the commercial property side are, is there direct physical loss over damage to covered property, which affects just about every type of coverage that might apply, whether it's business income or extra expense or contingent business or civil authority, and to the extent that policies have them, the various virus exclusions. Here to talk about the initial issue, the direct physical loss, are my friends Greg Varga and Sheri Pastor. Sheri is an alum of Seton Hall Law School, and a proud one at that, and is the current president of the American College of Coverage Counsel. She's one of the best policyholder counsel in New Jersey and is responsible for the case that gets cited all the time in favor of direct physical loss coverage. Greg Varga is a partner with Robinson and Cole firm in Hartford. He represents Travelers and a number of other major property insurers throughout the country on this litigation and is an excellent bicyclist in his spare time. So I'll hand it over to you guys.
Thank you so much, Mike. So I'm going to put a little bit of meat on the bones with Greg in terms of what Mike has set up for us. Before I do that, a little housekeeping. Greg and I are offering our presentations, just like many of the other panelists today, for educational purposes. And we are going to try to distill down in the next few minutes very complex issues. The views that we're sharing are not those of our clients or our firms, so please don't quote us in your next brief. in any event, so from the physical loss perspective, the real cornerstone of the issue that Mike is talking about on business interruption and property damage revolves around provisions like the one you see on your screen. And that is the part of the policy that speaks to having a direct physical loss of or damage to requirement. Property insurance policies have provisions very similar to this in most of them. And the language that I want to direct you to specifically is, if you look in the second sentence on the slide, you will see that there is a requirement of direct physical loss of or damage to property at a premises. A lot of the motions that we've seen so far have been related to whether there is a pleading sufficient to meet that requirement. There have also been a few motions for summary judgment, but primarily motions to dismiss by insurers relating to whether a policyholder actually pled what was required by their particular policy. I would agree with Mike that in terms of the dynamic of the litigation, what we are seeing is that early on, many of the pleadings that were filed, perhaps by people who are very skilled attorneys, but maybe not as nuanced in these complex areas, filed without allegedly these requirements. Because many of those policyholders were pretty desperate, they were out of business at that point or unable to open their practices and strapped for cash, the insurers were able to collectively decide in what cases to try to move forward and control a narrative about whether these types of cases in a business interruption setting can meet the direct physical loss of or damage to requirement. And what I'd like you to focus on for a minute is when you're looking at this provision, you will see that it contains the word or. So it is loss of or damage to. Policyholders typically make arguments, and when they plead, are mindful of the fact that these insurance policies are contracts of adhesion. You're often, as a policyholder, required to take them or leave them. And so what courts are grappling with is, what do the words that the insurers put in the policy with, loss of as opposed to or alternative to damage mean? And this issue has come up both before the pandemic as well as in connection with COVID coverage litigation. And as Mike mentioned, I handled a case called Wakefern versus Liberty Mutual, which was before the COVID litigation began. In fact, it was before New Jersey courts and went to the appellate division relating to the Northeast blackout. And that's one of those cases that had to attend to issues about physical loss early on. And it, like other courts, needed to consider what the requirement entailed. Now, I will tell you that in my view, Wakefern was the harder case. Wakefern did not have a provision that allowed for loss of or damage to. There are other cases that predated this litigation that did, and in those cases, many courts have found that the words are not synonymous, that the way the insurer put them in the policy means that they have different meaning before and after the word or. And so there are cases out there that actually are cited in the Wakefern versus Liberty Mutual decision, as well as in other litigations and decisions that speak to the fact that, at least as far as some courts are concerned, including the Wakefern Court, the requirement is ambiguous, and that in terms of the phrasing, that loss of, can you mean loss of function, loss of value? It does not mean necessarily a physical alteration such as damage. And in fact, there were many cases that were pre-Wakefern that we relied on. In fact, there were cases where, a house during a landslide was hanging off the side of a cliff, and the house was otherwise in good order, but for the fact that it was totally uninhabitable because no one could live in a house that was hanging off the side of a cliff following a landslide. There were cases that have dealt with ammonia contamination in facilities that have made them unusable during the contaminated period. There were cases that dealt with Snapple beverage, where the company did not rotate the beverages, and so the product, as it aged and came closer to the expiration date, had changed in terms of its value. And in all of those cases, courts concluded that the property damage requirement for physical loss or damage was in fact satisfied. Now, in terms of Wakefern, the reason I say that case I think would be the harder case, and frankly, there is some briefing on that case that I often don't recognize when I see it from other firms, is Wakefern, as I said, arose out of a power grid failure. And so when there was the Northeast blackout, Wakefern stores went dark and its food spoiled. The policy involved called for physical damage, and the insurer in that case essentially argued that there was no damage because although we were all sitting in the dark and food was spoiling, one could think of the power grid like your circuit breakers at home. Having tripped, nothing got damaged, all was well, it was a safety function, and therefore there was no coverage. That argument, as some of these have prevailed before the trial court, did prevail before the trial court, but the New Jersey Appellate Division disagreed, and it found that there was coverage. It looked at the larger picture. It considered the fact that there was a loss of function of the systems as a whole. It cited other cases dealing with loss of use and function, and essentially concluded that the coverage in that case extended and met the physical damage requirement. The other thing important about that case is the appellate division concluded there, as other courts have in other settings, that the requirement, when viewed from a reasonable policyholder's perspective and giving a policyholder its expectations when it read that provision, could be understood in more than one way and therefore was ambiguous. Because this was a contract of adhesion, the court determined that the policyholder's view would prevail. Pre-COVID litigation, there are also briefing out there by insurers. And I would say if you're involved in one of these cases, I would look carefully at what insurers have said in the past about these provisions. You will find, for example, that at least some insurers, when they were filing subrogation claims against other insurers, argued that physical loss and damage was very similar to how the plaintiffs currently argue it. And that in that setting, the environment and the aesthetics of a company were important. And if it could not be used, a facility for its intended purpose, that in fact was physical loss or damage. In terms of the first wave of these COVID cases, what we did see was that in the first wave, as Mike described, there were many motions to dismiss. There were policy holders that did not prevail because of their pleadings, but there were also cases And Greg is going to speak a bit to those where the policyholders did prevail on summary judgment. So in terms of where we are, Greg, where are we now in the second wave, and what did we see from the cases in the first wave that you think carries over and is of importance?
Yeah, I think briefly, Sheri, what we saw in the first wave of cases was the allegation by policyholders in almost uniformly that the inability to use their properties, their stores, their restaurants, their manufacturing facilities, whatever it was, because of government orders, was itself a physical loss of the property. And we and many other firms on the insurer side moved to dismiss those cases on the grounds that the mere inability to use property doesn't constitute anything physical. And there are other provisions of the policy that we argued applied to negate coverage for that outside of the virus exclusion. By and large, we were successful in those arguments. That is, the insurance industry was successful on most of the motions to dismiss that were filed around the country on that particular issue. There certainly were exceptions. We don't have time to get into all of that, but the second, what I would view as the second wave of allegations in the complaints that emerged were allegations where now we started to see policyholders say, actually, we did have virus that contaminated our property. In other instances, they alleged that statistical probabilities supported the conclusion that it was virtually certain that property at their premises was contaminated with coronavirus. In other instances, they alleged that there was an imminent threat of contamination, just as if a guillotine is hanging over someone's head. So all of these allegations began to appear in the complaints. So far, in the cases that we've seen, there has been a split among the courts on the allegations of actual presence of virus. In some courts, like Studio 417 in Missouri, for example, the court held that allegation of specific contamination of property by coronavirus is sufficient to trigger the direct physical damage requirement. Other courts, like Tapo of Buffalo versus Erie, Moody versus the Hartford, and Uncork and Create, some cases out of West Virginia and New York and Pennsylvania, courts held that allegations of virus on the premises was not sufficient because it is entirely possible to remove the virus from surfaces and objects through household cleaning agents and simple cleaning that restaurants and other places of public accommodation are expected to do anyway. So that issue, virus on the premises, is still something that's working its way through the court system. I think so far from what we've seen, allegations of imminent threat of contamination or statistical certainty, those have not been terribly successful so far, but there still are many cases that are briefed and awaiting decision. So there is, I do want to raise just in the minute or so that we have left, there are two very interesting cases, and Mike alluded to these earlier. They are mass actions, and that is a large group of policyholders against a large group of insurers. And it's the Jenner and Block firm that brought the two most prominent cases. One of them was brought in Cook County, Illinois, the other in Kings County, Brooklyn, New York. Both have been removed to federal court and remain there for the moment. But those cases raise interesting allegations about direct physical loss, which I just want to touch on for a moment briefly. Instead of alleging that they lost the use of the premises or that there was actual virus on the premises or even the threat of it, the allegation that they have made in these cases is that in order to remain open for takeout and delivery, for example, and comply with orders from the government, restaurants and cafes were forced to make, quote, detrimental material alterations to the premises that included things like moving their tables around, blocking off seating areas to prevent customers from dining there, installing plexiglass dividers where customers could place orders, and putting social distancing decals on the floors. The allegation was that those changes made to comply with requirements of ordinances and emergency orders were physical damage to the property. And then they further alleged that when they were allowed to reopen restaurants and cafes on a limited basis for outdoor dining, they had to make other modifications, quote unquote, material alterations to the premises, including moving tables a certain distance from one another and providing separate entrances. And again, all of these allegations are in support of the concept of physical damage. And so, Sheri, I throw it back to you. Your thoughts on the question of whether, for example, installing plexiglass dividers, decals on the floors, and putting up additional signage reminding people to maintain their distance constitutes direct physical damage. What's the argument from the insured side?
That these are all risk policies, and what many of them mean are, unless the policy contains a specific exclusion, it's covered. Early on in the litigation, many insurers sent out letters to their policyholders and put up notices on their website saying, there is no virus present. The virus didn't cause the orders that were entered shutting you down. What shut you down was, in fact, these executive orders. And in this case, the executive orders required certain things, like all of the things that you described, to physically reopen the premises, and that will eventually need to be restored or repaired when we get past the pandemic back to their pre-pandemic state. So in terms of the pleadings, I would say that in terms of looking at that, ordinarily courts, if there were a motion to dismiss, would accept as true all of the well-pled factual allegations and be hard-pressed to dismiss a complaint where there are allegations of not only loss, but damage to a premises.
And I'm sure those are among the arguments that we're going to hear from Jenner and Block at some point in these cases. I think just briefly for about 30 seconds, because we're over time, I think it will be interesting to see how the argument plays out. But I think one thing is notable in particular. I would agree with you. These are all risk policies, but they're not all loss policies. And what we're talking about is physical loss and physical damage. And so I would raise the question, look, restaurants or places of
I think Greg is frozen. So let me make a comment until.
He's back.
Greg, you were frozen for a minute. In any event, my comment was going to be, I agree with you that
there's some very interesting issues on direct physical loss with these cases, as well as possibly fortuity, that we may have to discuss at another point. But any final thoughts?
I would disagree that these are not necessarily all loss policies. They cover physical loss unless otherwise excluded. In terms of fortuity, I would say that the pandemic and the orders that followed from it were not intentional. And frankly, once these establishments had loss and damage, they were required, probably the insurers would argue, to mitigate their loss. It probably is no different, if you will, than when there's a fire and someone has to pour water on it, even though it might do damage, or axe down doors to prevent it from spreading. But thank you, Greg. At this point, I'm going to turn it over for a discussion on, will the virus and microorganism exclusions prevail? And in connection with that presentation, I'd like to introduce you to Joyce Wang and Lorelie Masters. Joyce is the founding partner at Carlson, Calladine, and Peterson, where she has been a nationally recognized litigator in the area of insurance coverage and bad faith for over 30 years. She's represented property and casualty insurers and reinsurers, as well as policyholders in property and casualty disputes. She is actively involved in COVID-19 litigation matters and admitted in California and Hawaii. Lorelie Masters is a partner at the law firm of Hunton and Williams. She is a policyholder attorney who handles all aspects of complex commercial litigations and arbitrations. She has a wide range of coverage disputes that she's involved with, including the first party property insurance, and her practice takes her not only to state and federal court around the country, but she's also involved in arbitrations in the US and abroad.
Hi, everyone. It's Lori. Glad to see so many friends on the list of participants and weighing in on the chat. Could you please advance to the next slide? So Joyce and I are here to talk about exclusions. We have a list here of what we think are the ones that are coming up most frequently in these cases. I think all of us in the group here are probably aware of this. Obviously, the virus exclusion, the 2006 ISO exclusion, is front and center. Although I would note that a lot of policies I'm seeing, and I think it's true from the cases that are reported, don't involve a virus exclusion. In those cases, there's often other exclusions that have been raised, and we put these in this list. So some of them, like the pollution exclusion, may not include virus, but they may. And so I think we will, and we're seeing this in the cases, we'll have fun discussing the meaning of that. And I think that the coverage wars from the 1980s and 90s on pollution exclusion, sudden and accidental, and absolute, so-called absolute pollution exclusion will provide some past as prologue issues here. I would like to say that I think language, as I just said, and the nuance in these provisions really matters. There may be, we don't have this in our slides, but there may be anti-concurrent causation language or an anti-concurrent causation exclusion that will affect the analysis. Sometimes these exclusions are added by endorsement. And my experience is that the endorsement may be limited to certain parts of the policy, certain coverage parts, the property damage part of the policy, and not the business interruption or loss of business income type of coverages. Also then there are going to be, I think, fights over discovery in these situations. Are we going to see the various submissions that were made to different insurance commissions around the country? Some states like California, and Joyce can probably talk about this better than I, require specific submissions by individual insurers rather than joint or more omnibus submissions generally by an organization like the Insurance Services Office. But Joyce, I'd like to turn it over to you.
Sure. If we could advance to the next slide, please. So this is some language from a couple of different versions of virus exclusion. The first one being the one that Lori just mentioned, the ISO 2006 form. It's a sort of a garden variety, if you will, exclusion, just saying we will not pay for loss or damage caused by or resulting from any virus, bacterium, or other microorganism that induces or is capable of inducing physical distress, illness, or disease. And then there's another example of one below that. This exclusion, the vast majority of courts that have confronted motions addressing this exclusion have found that the plain meaning, excuse me, of the exclusion quite clearly applies to the virus that causes COVID-19, SARS-CoV-2, because it is a virus. Virus means virus, and SARS-CoV-2 falls under the exclusion. There's quite a few decisions that have aligned with that view, both in California. We have quite a few in California, about half a dozen in the Northern District alone, and maybe 8 or 10 in California federal court decisions, as well as outside California. There have been quite a few decisions, courts that have found that SARS-CoV-2 losses are excluded by the virus exclusion. And from an insurer perspective, which I do most of my work for the insurer side, the nice thing about the virus exclusion as a defense is it's hard to create a question of fact or require discovery necessarily if the plain meaning of the exclusion applies. You have a shot at getting out on the pleadings. And that's in fact what many of these cases have been, motions for judgment on the pleadings or similar motions to dismiss. So it's a good way, if you've got a good exclusion, to potentially shortcut the litigation and end it early. If you've got the good exclusion, unlike the physical loss or damage argument that was just discussed by Sheri and Greg, which can invoke more questions about whether it was on the property and whether it can be cleaned and whether it causes damage and so on. The virus exclusion is a little bit more of a cleaner shot. And courts have been pretty strong on finding that SARS-CoV-2 is a virus. And there's even a case where, particularly if the exclusion mentions the word virus, I think that's a very strong majority on that. There is a case where the exclusion did not mention virus, but was rather a pathogenic organism exclusion. That's the boxed foods case, and the exclusion just excluded, damage from the presence of any pathogenic organism. And the court found that applied to SARS-CoV-2 because it's a pathogenic organism, even though the exclusion did not use the word virus. So I think courts it's pretty clear cut, I think, and a pretty straightforward analysis for a court. Now, if you don't have a virus exclusion or you have one of these other exclusions, I do think it's going to be more of an uphill battle. And I think we're going to talk a little bit more about some of the other exclusions that are being raised that are a little bit less directly applicable. Lori?
So let me just weigh in on a couple of things there, some maybe counterpoint type of ideas. One case to think about, all of these cases are going to depend on their facts, the facts of the language at issue, but the Elegant Massage case, for example, coming out of the Eastern District of Virginia in December of last year, said that the virus exclusion did not apply there because the policyholder had not alleged the presence of COVID-19. So there are different ways that policyholders are looking at these policies that may have virus exclusions. And when I say virus exclusions, I mean real virus exclusions. I don't mean from our perspective on the policyholder side, the faux virus exclusions. With regard to the virus exclusion, we also think that it's important to look, as I said earlier, to the filings. The ISO circular that was filed in July of 2006, we think specifically makes distinctions that can be relied on here. It also talked about the fact that there made the representation that there had been no cases, case law in effect, where disease-causing agents had been found to cause direct physical loss or to trigger, I guess I should say, coverage. But that's simply not true. And I think any of us who've practiced in this area for any length of time know that that's not true. There are a couple of cases just off the top here to mention. One came out of the Third Circuit and Sheri came out of the Third Circuit in 2005 under Pennsylvania law, saying that E. coli contamination constituted direct physical loss. So from our perspective, there may be issues arising in terms of the, just as there were with pollution exclusions back in the day, with the representations that were made to get approval of the exclusion. So let's move on to the pollution exclusion. If you could please.
Lori, if I may just interject, I see that there's a question in the chat about whether any court has drawn a negative inference against an insurer if their policy doesn't contain the virus exclusion because the exclusion is so readily available, I guess. And I'm not aware of a case that has found that. I certainly think that that is an argument and probably a pretty persuasive one, that if an insurer doesn't include a virus exclusion, you know, they didn't mean to exclude virus because it's readily available on the market and so on. So, you know, I think that's an argument that we will see if it's not been made already.
Yeah, Mike's putting in the chat that no court to date has, but certainly, Mike Aylward, but certainly we're seeing that. I would say that's in some of the cases that have gone up on appeal, those arguments have been made. And so we'll see how the courts address that. Certainly from the policyholder side, we think a persuasive argument can probably be made. So we want to talk, since we're probably running behind here, about a few of the other exclusions that we're seeing come up in these cases. So pollution exclusion, Joyce mentioned this earlier, is I would say a prime example. Now the language on the screen here is what I would consider a traditional absolute, in air quotes, pollution exclusion. You see the definition of pollutants there does not include virus, but some of them do. And so from my perspective as a policyholder lawyer, I think this one's easy. This gets to the point. In a lot of cases, states, I should say, New York, California, others have said that pollution exclusions are intended to preclude coverage for traditional environmental or industrial waste disposal or pollution. And that's not what we have here. A more difficult case, and I'd love your perspective, Joyce, is, you know, the pollution exclusion that does mention virus. We would say that that doesn't change the analysis, but certainly we're seeing arguments made in a lot of cases that a pollution exclusion that has virus is a, quote, virus exclusion.
Well, sadly, there's one case in a state court decision out of Las Vegas, the JGB case, that talks about a pollution exclusion. It's in the exclusion context, and the pollution exclusion contains the word virus, but it lists the traditional pollutants, you know, smoke, vapor, soot, fumes, acid, alkalis, chemicals, virus, waste. And the court, in my view, without really any basis, found that the exclusion really was intended to apply to traditional environmental and industrial pollution and not a virus. And therefore, you know, that was a reasonable interpretation of the exclusion. You know, my criticism of that is that interpretation really reads the word virus right out of the exclusion. There's just really no way around that, I don't think. But there is that, you know, that case is out there. I don't know whether that's being appealed or what the status of that one is. But there is at least, you know, one court that felt that the word virus didn't mean virus when it was grouped with these other traditional industrial pollutants.
So could you please advance to the next slide? We're going to tick off a few more exclusions here before we turn it over. So another example of exclusions that has come up in these cases is what I would consider a fungus exclusion, but you know, we wanted to put it up here so you could see the distinctions between potential language here. So I think this makes it clear. The first one is I would say a real, quote unquote, real fungus exclusion, doesn't mention virus. The second one then brings in virus. And so what does that mean? Certainly Joyce just articulated the argument with regard to the pollution exclusion, we're going to see that, I think, also in the context of these kinds of exclusions. And some of the policies that we've looked at, this is the exclusion that's there. There's not a virus exclusion. There may not be a pollution exclusion. Certainly the pollution exclusion may not mention virus, but it may have this. So we'll have some fun, I think, with policy interpretation arguments.
And there is actually a case in the Northern District of California that interprets the second version of the exclusion that you see on the screen. That does include the word virus. That's the Franklin decision, and it held that that exclusion, it was those exact words actually, applies to SARS-CoV-2.
So I'm going to come back with the urogynecology case out of the Middle District of Florida, where the court there talked about an exclusion that included bacteria, fungi, dry rot, and virus and other pollutants, and said that none of the cases that had in effect addressed these kinds of exclusions in the past had dealt with the unique circumstances here with COVID-19. And the court considered that an important distinction. So before we close, let's just put up the next slide. These exclusions are coming up, I would say, frequently. At this point, I haven't seen them be a significant problem. We're focusing more on the virus and pollution exclusions, for example. But Joyce, what's your thought on these exclusions?
Yeah, I haven't seen it be the primary argument, although I have seen some cases where instead of alleging that, SARS-CoV-2 or the pandemic caused the loss, that really it was governmental orders, closing businesses and so forth that has caused the loss, and that a loss of use should, qualify for coverage. I haven't seen that argument get a lot of traction yet. There's a body of case law out there in the non-COVID context that says that, the insured has to has to have something more than just the loss of the use of their property in order to establish coverage. There has to be some physical aspect to it. So it remains to be seen whether this gains any traction over the coming months, but I haven't really seen that yet.
I would say on this one that these delay and loss of market exclusions were a big deal with September 11th losses. And there you did have circumstances in downtown Manhattan where perhaps the concourse of the World Trade Center was never coming back. That was a loss of market. This is, in my view, not a loss of market in that sense, but we'll see how that plays out. And just wanted to put up the last slide here. This is an exclusion that I saw came in for one of my clients on March 18, 2020. So just less than a week, I would say, after lockdown. So this is an exclusion that an insurer put in to be very specific about COVID-19. And this was specifically from event cancellation insurance, where previously, the previous year's policy had explicitly covered communicable disease and bought back a previous communicable disease exclusion. So I think that's a big issue that we'll see going forward. And one other, well, there are probably other exclusions that we haven't mentioned. One that came up in the chat I thought was interesting. I'm not certain I have a great response to it at this point. I think it depends on the facts, is the law and ordinance exclusion. That with some of these changes, as we were talking about with the restaurants at the end of the last panel, is that precluded by some kind of law or ordinance exclusion?
Yeah, I haven't really analyzed that issue, but I believe most law ordinance exclusions pertain to a law or ordinance governing construction or repair of a property that's been damaged. So I don't know that that would apply to a government order closing down a business that's not government, that's not controlling an actual repair. But I don't know if there's other forms of that exclusion that might be out there. So.
Well, with any of these issues, from the policyholder side, I'm going to put my plug in there. If there are reasonable interpretations that policyholders can make and that perhaps courts have accepted in this context, COVID-19 or other contexts, we only have to show that we have a reasonable interpretation, and insurers have to show that their interpretation is the only reasonable interpretation. So we may be, it's early days, I would say. A lot of the losses have been in cases that I think Mike put very well, weren't pled the way some of us would think, or perhaps the courts haven't, in my view, given or have given short shrift to the policy interpretation obligation that they have. But we'll see how that works going forward.
We will indeed. Thank you very much, Joyce and Lorelie, and our panelists.
Welcome.
Let's pivot now to liability claims. Almost all of the litigation at this point is business interruption losses, and honestly, that's where the dollars have been. But it's only been a year since this started, and our courts have really been tied up pretty much in terms of any kind of activity. The liability claims will come. And as time passes and the full consequences of the pandemic are clearer in an economic standpoint, it seems likely that we'll see claims against directors and officers that may trigger claims under D&O policies. It also seems likely that we'll get professional liability claims, particularly those involving health professionals who may have misdiagnosed or mishandled COVID cases. And finally, one liability area that we're already seeing are suits against employers for either requiring people to work in dangerous conditions or refusing to allow elderly employees to work when they wanted to, that are being presented under EPL policies. While the fate, whether we're going to get CGL claims is a mystery at this point, stay tuned. It is almost certain, though, that we're going to start getting D&O claims soon, in which plaintiffs allege that businesses and directors have mishandled the crisis. And we have two of our finest D&O lawyers here to talk about that. One, Mike Manire from New York, and Seth Lamden from Chicago. Mike is the founding member of Manire Galla, where he represents some of the world's largest D&O and E&O carriers in connection with complex claims. Mike is past chair of the college's D&O Liability Committee. Seth is a partner at Gerber Eisenberg in Chicago. Sorry, it's cold there. And a past chair of the Insurance Law Committee at the Illinois Defense Trial Association, and the incoming chair of the ABA Insurance Coverage Litigation Committee. Seth will present the policyholder perspective on these D&O issues. Seth and Mike, I turn it over to you.
Thank you, Mike. And as Mike has said, this conversation shifts sort of more almost to the abstract or hypothetical, because there really haven't been much in the way of coverage disputes arising out of D&O claims. There haven't been a whole lot of D&O claims made that you would really call COVID related. But the way that Seth and I are dividing up our tasks today is I'm going to talk about the public company side of D&O coverage and the sorts of issues that may arise there. Seth will talk about the private side. He and I sort of disagree on which one is more interesting. I think the more interesting coverage is used on the private side than the public. But on going with the public side, the primary difference between the private and the public, of course, is that there's entity coverage on the private policies, broad entity coverage, which leaves them exposed to lots of different kinds of claims. Whereas on the public company D&O policies, the only entity coverage provided, of course, is for securities claims. In that regard, there have been a couple of interesting decisions recently out of Delaware, which has been sort of the source of a whole lot of interesting, if you will, coverage decisions lately, about out of the Supreme Court, and then the In re Verizon case and the In re Solera case in 2019 and 2020 about what a securities claim is. But for the most part, they are what you would imagine securities fraud claims, shareholder claims alleging breaches of fiduciary duty, and so forth. The those are the bread and butter claims on public company policies. What we've seen in the COVID area so far on the securities fraud side is about somewhere between 25 and 30 cases of what you would imagine where a company makes statements publicly about either the impact of the COVID or the pandemic on its business, or whether it may have some product or service that's going to be particularly affected positively by the pandemic, and it turns out not to be the case. Those cases have not developed very far. There's been one recently dismissed, but the facts were pretty narrow. Not much to learn from that. Probably the most interesting one I've seen is one very recently. It's a biotech case called Peter Lung versus Bluebird Bio in the Eastern District of New York, and there the company had was developing a new genetic sickle cell disease treatment product. And was making projections in its public statements about when it thought it would be able to get FDA approval of it. It turns out that COVID intervened, and for reasons that included supply channel issues with respect to how they were able to continue to develop the product, and others, they fell behind in that schedule. When that was announced, their stock dropped, and boom, there you go, you've got a securities claim. These don't raise particularly specific coverage issues as far as COVID related. The policies generally have bodily injury exclusions, they have property claim exclusions, property damage exclusions. So we are really looking at sort of economic damages for securities and fiduciary duty claims. The most interesting cases to me, and the most interesting cases that'll come out in the public area for coverage purposes, are going to be the derivative claims. There really haven't been there have been some that are pretty much copycat derivative claims that come after a securities fraud claim, alleging it was, you not only committed securities fraud, but in doing so you breached your fiduciary duty and therefore injured the corporation. There will be, I'm sure, a number of those coming up in the what's called the Caremark world, which is particularly in Delaware fiduciary duty law, the issue of what duty a director or officer has beyond specific situations of just overlooking the company's business. And after a recent Supreme Court decision out of Delaware, having to do with the Bluebell, I think it is, ice cream company. That was, what claim was that? Was a Marchand versus Barnhill decision in June 29. Bluebell Creameries was an ice cream company. They developed I believe an E. coli issue, some bacterial issue in the manufacturing of their product. They were sued by shareholders. The board, I should say, the directors and officers were sued by shareholders, alleging that they had breached their fiduciary duty by allowing that to happen. Interestingly, it's difficult to plead those cases because the standard is very difficult to reach for liability under those circumstances where there's no conflict of interest and so forth. But the Delaware Supreme Court reversed the lower court's decision in that case and found that they stated a viable claim, partly because the product, they have basically a one product business, and the notion of maintaining the safety and purity of that product was so fundamental to the company that it imposed this particular duty for them to be on top of that issue and to protect the company from that sort of thing. The sorts of coverage issues you're going to see there. So you're going to see some side A issues in the derivative cases because as we've seen in the last few years, there have been a lot of derivative cases ending up in large settlements where D&O carriers are actually paying not only the plaintiff's attorney's fees, but large damages settlements resulting from them. That's going to come up. You'll see side A issues come out of bankruptcy claims that are going to result from this that will implicate the D&O policies. Those are claims against the Ds and Os that are essentially derivative claims as well. And I think one that is inevitable that's going to come up a lot, and I spend way too much time in my practice on this already, is the related claims issue. These are claims made policies. inevitably the policies have to try to determine whether one claim that's filed after another, and one in one policy period and the other in a following policy period, are essentially, loosely speaking, the same claim, and are going to cover it under just the earlier policy period. That's a very typical dispute, and I'm sure that's going to come up in this instance where if a company is really hit hard by COVID problems, it's going to have disclosure problems, it's going to have fiduciary duty problems, other problems will come up over time, and the fight over whether something is related enough to the other to relate back will come up quite a bit. Delaware has been a location for some interesting decisions on that one as well lately, typically policyholder friendly, but there's going to be a lot of action in Delaware on some of these issues. With that, I will hand it over to Seth to take us down the private side.
Thanks, Mike. So I'm going to be spending a few minutes talking about D&O policies issued to private companies. As Mike mentioned, I think one of the key differences between public company D&O insurance and private company is the breadth of claims against the entity itself that are covered. Sure, private company D&O policies do cover security claims, but also can cover claims brought by customers and creditors, shareholders, and competitors, regulators, et cetera. So while I haven't seen any specific D&O coverage disputes arising out of the pandemic, it certainly doesn't take a lot of imagination to think of all the myriad claims that'll be brought against private companies. And given the breadth of private D&O coverage, a lot of those will respond. And there are a few exclusions in D&O policies, private company D&O policies, that I think very well might be implicated in those claims. And there's a couple I'd like to talk about. And really, when I say those claims, I really mean any claims arising out of the pandemic. The first are most private company D&O policies have some form of exclusions for bodily injury and also have exclusions for property damage. Now, these exclusions can be worded in a number of different ways, obviously, but the key factor in these exclusions is some are worded to eliminate coverage for claims for bodily injury, and some are worded to eliminate coverage for claims arising out of bodily injury. Similarly with pollution, there could be an exclusion for claims for pollution or for claims arising out of pollution. Now, there has been a lot discussed about whether COVID-related contamination can constitute pollution. I think that's unlikely to be the case, but I recognize that some courts are at least wrestling with that now. So I think where the real key is going to be is, do claims that arise out of the COVID pandemic implicate these exclusions? There's not a lot of case law addressing these, but there are two cases I'd like to discuss briefly because I think they sort of illustrate the two ways in which courts can evaluate these. The first is a New Jersey appellate case that was issued in 2008. The insured in that case was a manufacturer of products that included, it had some legacy asbestos liabilities. In its financial reporting, it allegedly failed to disclose the extent of these asbestos-related liabilities, which led to a drop in the price of the stock when that disclosure was made. And there were follow-on securities claims brought against the company, alleging damages due to the inadequate disclosure. It was a private company. The D&O insurer in that case denied coverage. Among the reasons for which it denied coverage was an exclusion in the policy that eliminated coverage for claims arising out of pollution. I think it was probably the discharge or presence of contaminants, and in that case, asbestos was deemed to constitute a pollutant, at least for purposes of that issue. The court found that the insurance company was obligated to cover the claim, that the exclusion did not eliminate coverage because the crux of the claim against the insured was inadequate disclosure of liabilities. It was a financial issue. It was not a claim for asbestos-related liabilities. And the court found really that you need to look at really what's the crux, the gravamen of the claim. Was it an asbestos liability claim or otherwise? However, there was a Fifth Circuit case decided 4 or 5 years earlier applying Texas law that included a similar exclusion. It eliminated coverage for liability arising out of claims for discharge of pollutants. That case was the insured was a company that was involved in the treatment and management of waste products. It was sued for illegally processing and disposing of waste products, which led to a criminal investigation. It led to a number of other civil investigations and ultimately a suspension in the trading of its stock. Shareholder suits were brought against the insured, and the D&O insurer in that case denied coverage, again, relying on this exclusion. Under Texas law, unlike the law of New Jersey, under Texas law, the court found that the exclusion did eliminate coverage. It applied a but-for analysis and held that, but for the illegal discharge and treatment of contaminants, that there would not have been a claim, and therefore, court found that the insured was not entitled to coverage in that case. So I think you can see that those are sort of the two sides of the coin, where assuming, if contamination by COVID constitutes a pollution condition, for example, that's the sort of analysis I think that we're going to see. To the extent that claims are brought alleging, failure to prepare for the impact of the pandemic, et cetera, there's certainly always going to be some nexus, albeit quite remote, to the pandemic and perhaps bodily injury. A couple other exclusions I think just we're going to see quickly are going to be, as Mike mentioned earlier, there's going to be professional services related claims brought against insureds. Private company D&O policies will typically have exclusions for professional services and also for products. So given the number of professional service providers and entities that are providing products in connection with the pandemic, certainly suits may be brought against them. I think those exclusions very well might be implicated, but that's certainly nothing unique to the pandemic itself. But as the cases begin to get filed, presumably D&O claims will follow, and some of these issues will be further developed. Mike?
I will add one more thought about it. I mentioned that there are not a lot of coverage issues to talk about on the public side, which is certainly truer today than it used to be. But one that will likely come up in the narrow circumstance of M&A litigation will be the so-called bump up exclusion, which some policies provide that they're not going to pay a loss if what the loss consists of, that is the damages in effect, consists of is an effective increase in purchase price when one company acquires another. There's a recent decision, and if that happens, for example, if the acquiring company is a company that has COVID issues and doesn't handle its disclosure properly, then acquires a company by issuing a shares to the acquired company shareholders, they could get sued for those misstatements with respect to COVID. The recovery would be, well, they have to pay more money or more shares to the other shareholders, and that will call into play this so-called bump up exclusion. There's a recent, all roads seem to lead to Delaware these days, a decision called Northrop Grumman versus Zurich, just 2 or 3 weeks old, on finding that a bump up exclusion did not apply under a similar circumstance. That issue is being litigated in other courts at the same time. So that's one to keep our eye on, the D&O space.
Thank you, Seth and Mike. Whereas directors and officers' claims may be speculative at this point, although they do seem likely to emerge, EPL coverage is here and now. I have a lot of claims that are already being presented by employers seeking a defense. And here to talk about whether employment practices liability applies are Laura Hanson and Chris Mosley. Laura is the chair of the insurance practice group in the Minneapolis office of Mayer and Gear, where she's been working with insurance companies around the country for the past 35 years. She's served as co-chair of the ABA section of litigation's Insurance Coverage Litigation Committee in 2013-16, and has been active in this area more recently. Chris Mosley is the founder and head of Sherman & Howard's insurance recovery practice. I'm still not sure what an insurance recovery is. I hope to find out someday. For the past 3 decades, he's represented corporate policyholders in complex coverage cases, including EPL, and more recently claims by clients analyzing and pursuing COVID-19 insurance claims. So Chris and Laura, have at it. Is there EPL coverage for COVID?
Absolutely. So now to the next presentation. No, I want to thank Mike for that. And insurance recovery is, of course, those rare circumstances when an insurance company wrongfully refuses to pay benefits and we're asked to recover it. Laura and I are going to talk about some of the types of claims that are out there for that will implicate EPLI insurance. And really, this at this stage of the game, since we're pretty early in it, it's really going to be an exercise in issue spotting, and it's going to be an exercise in really taking a strong lesson in looking at the language of the applicable policy very closely to the word, to the definition, like that. So what we thought we would do to start, and if we could move to the next slide, would be to give some examples of the types of claims that we anticipate that we're going to see that are going to implicate EPLI coverage. So the first is health and safety practices. There, we're talking about a situation, for example, where an employee contracts COVID at the workplace and alleges that the employer had insufficient health and safety practices in place that led to the employee's infection. Another spin on that would be that the allegation is the employer negligently trained its staff in health and safety practices, which led to the employee's infection. And in our little scenario here, the employee alleges bodily injury and mental anguish. A second type would be the failure to comply with the government mandates. In this situation, we're talking about an employee who asserts that the employer has not complied with governing law and regulations with respect to health and safety practices. So such things as masks, social distancing, things of that nature. Thus increasing the risk to employees of contracting COVID. A spin-off of this would be the allegation that the employer then retaliated against the employee for reporting the employer to the appropriate regulatory authorities for failing to comply with the health and safety practices. A third one, which I think a lot of employers potentially are at risk because of the ubiquitousness of COVID-19, is the disclosure of personal health information. Here, we're talking about a situation where the employee asserts that while the employer was conducting contact tracing, which by all accounts is a very good thing for an employer to do, the employer discloses private health information of that employee in violation of privacy protections. A couple more, retaliation. This would be one that I think we're likely to see a lot of. The employer refuses to comply with the COVID restrictions imposed by the employer. And let's assume for the sake of argument that those COVID restrictions are appropriate, or at least arguably appropriate. And so the employee is fired. The employee then sues for retaliation, asserting that the employee was just exercising his or her rights under OSHA. Then you have the discrimination cases. We have a situation, of course, where the pandemic has caused substantial losses across employee losses across the country, especially in the hospitality industry. And consequently, employers have had to furlough groups of employees. In our scenario here, an employee may sue an employer asserting that the employer, in deciding who to lay off, discriminated against an entire class. This is a particular one with respect to older workers. And then finally, for purposes of today, paid leave. We've got the Families First Coronavirus Response Act that have certain paid leave requirements. And in the scenario that Laura and I have discussed, we can see a situation where an employee is going to contend that the employer failed to provide paid leave under the Act. Is that going to be covered by a policy, by the EPLI policy or not? We'll talk about that in a little bit. Laura?
Thanks, Chris. Can we move the slide next? Yeah. So I'm going to talk a little bit about what EPLI policies cover. As you all know, they're typically claims-made policies, and claim is a defined term, as it often is in these claims-made policies, that it's a written demand or a civil or criminal action or administrative or arbitration matter. And the insuring agreement typically provides for coverage for loss for loss that's legal, that the insured is legally obligated to pay for a wrongful act or a wrongful employment act. That's a defined term under these policies, and that does vary. EPLI policies do vary often by carrier, but also by industry. So it's really important, as you hear all the time in these presentations, that you've got to look at the policy language, but they do vary quite a bit in this arena. And so I'm going to talk in general about some of the kinds of standard forms that we typically see. So they provide coverage for wrongful employment acts, which include the sort of employment practices you would expect, like wrongful demotion, wrongful termination, failure to promote, wrongful refusal to hire. Breach of an implied employment agreement is often included in the definition of wrongful termination. And then discrimination and harassment, of course, retaliation, as Chris described. There's also a failure, typically included in the definition, is the failure to provide or enforce appropriate or adequate workplace policies and procedures. It's kind of a big catch-all, and so many negligence claims may potentially fall within that provision. And then there's coverage for defamation, for libel, slander, and invasion of privacy in most cases. The exclusions in this area vary, of course, also by the type of carrier and the type of form, but there's almost always an exclusion for the deliberate, fraudulent, or criminal acts of the insured. But most forms will provide a defense to the insured until it's judicially determined as to whether or not the conduct was deliberate, fraudulent, or criminal. There's an exclusion for bodily injury and property damage, but most forms also note that emotional distress and mental anguish, humiliation, or loss of reputation are not excluded. The bodily injury and property damage is, but that kind of a claim is not. Then there's the violation of law exclusion, and that I'm just going to describe as the standard employment legal requirements that all employers must comply with: OSHA regulations, National Labor Relations Act, the Equal Pay Act, ERISA, WARN violations, those sorts of things. And then there's always a catch-all for similar federal or state statute or regulation. That's going to come into play in these types of claims as well. The forms vary as to whether or not there's a breach of contract exclusion. There are some that contain a breach of a written employment contract or agreement, but provide coverage for an allegation of an implied employment contract. The definition of loss is relevant, and it's relevant too with respect to this kind of a claim related to COVID. It does include, standard costs of settlement, the compensatory damages, punitive if they're covered under governing law. It won't include fines and penalties or anything uninsurable. But defense expenses are often included, and so that plays a role in terms of how the case gets handled once it's being defended. Back and front pay is typically included, but other types of future salary obligations are not. So non-monetary type of awards would not be covered, like requirements to accommodate disabilities, that sort of thing. That's not going to be covered under the policy. And not any salary obligation that's owed pursuant to a contract or any future salary obligation. But front and back pay are typically specifically identified in the definition of loss. That's just a very quick and general summary of what EPLI coverage is like, what kinds of exclusions we think we would end up looking at with respect to these kinds of claims.
So if we move to the next slide, what we're going to do now is go through a little back and forth on a couple of the examples that I had given to show you the type of thought processes that policyholders and carriers and the council who represent them should be thinking about when they're looking at the potential for EPLI coverage. I'm going to do a quick note on this particular slide. From a policyholder perspective, it is absolutely critical that these claims get tendered timely. Virtually every EPLI policy that I have seen is a claims-made policy, whether the policy is a standalone policy or attached to some sort of management liability policy that includes D&O coverage and other types of coverages. Most states, not all, but most states have very strict rules supporting the insurance industry where policyholders fail to tender a claim within the period of time required by the policy. And that is specific to claims-made policy. Courts go the other way for the most part on occurrence policies. So it's very critical from a policyholder perspective to tender timely. There are a lot of things that happen when you get these lawsuits. You've got to pacify the employee, you've got to talk to management, talk to shareholders, find a lawyer, do all these different things, but make sure that at the top of that list or near the top of that list is tendering timely. And really have to focus on your policy language. And we're going to, Laura mentioned some of the more typical definitions that we've seen. I started to say standard and then I stuttered and stopped for a reason, because while EPLI policies are becoming a little more uniform, they're not. They're certainly not like CGL policies. So as a general proposition, we're talking traditional employment type claims, discrimination, harassment are covered. Other types of claims like bodily injury typically fall under a different type of policy like CGL. If we could move to the next slide, we'll do the back and forth on three of the examples that we've been talking about. So the first one, as you recall, when I went through this, or the second example that I provided was failure to comply with government mandates. This is where the employee asserts that the employer hasn't complied with the relevant health and safety practices that may be imposed by state or local authorities. And as such, the employee asserts that the employee and all other employees are at an increased risk of infection. And in some circumstances, we might have a situation where the employee asserts that it was retaliated for telling on the employer. And so in that circumstance, as a policyholder, I think the key here is to focus on the employment practices wrongful act definition. And you have to look at the specific definition of this policy. What are some of the things off the top of my head that I'm going to be looking at and thinking about? Does the retaliation is what it is, and that's generally a covered claim. But what about just simply damages associated with failing to comply? I would argue that perhaps that constitutes an abusive or hostile work environment, which frequently is within the employment wrongful act definition, or possibly breach of an implied employment contract, that is the implied contract for a safe workplace. Or could I argue that under the applicable law, this would constitute false imprisonment? These are things that you have to think about and perhaps consult with an employment expert if you're not. The third item that I had mentioned was disclosure of PHI. This is a great concern because of the extent of contact tracing that all sorts of places are doing. I particularly see it at the university level. I happen to have two kids in college right now, and there's contact tracing going on there every day. So here I would look at the employment practices wrongful act definition, and in particular to see if that definition includes claims related to workplace policy and procedures. And I would suggest here that my argument would be that the company has a procedure in place, whether it's implied in law or express, not to disclose personal health information, and you did it. What are my damages? Well, probably emotional distress, but we'd have to see. But that would be my argument for the initial trigger of coverage. And the last one I wanted to just give you an example of before turning it over to Laura for her view from the carrier side is the paid leave piece. And that is the situation where the employee contends the employer failed to provide the paid leave that the Families First Coronavirus Response Act provides. Here, now I think we're talking about the definition of loss. And as Laura indicated, the typical definition of loss would constitute front pay or back pay. So as a policyholder, what am I going to argue or at least consult with my employment law specialist? does the paid leave provided under that act constitute front pay or back pay? Because I'm trying to shoehorn this in to coverage, or as Laura will probably indicate, does it constitute some other type of wages? So these are the things from the policyholder perspective that I would look at. 2 quick lessons on that as I turn it over to Laura. Read your language, and if you're not an employment law expert, consult with your employment law expert. Laura?
Thanks, Chris. As usual, I just think you went down the wrong path on all. Okay, so I will start with the failure to comply with either state or federal mandates or statutes. The general rule of thumb in these types of policies and what a carrier would be thinking when a third-party lawsuit comes in against an insured is, if this is really just a failure to follow the law, then it's not going to be covered unless there is a retaliation claim, because all of those exclusions, which say that if you're just the claim is for failure to comply with the law, whatever it might be, there's no coverage for that. It's specifically excluded unless there's a claim of retaliation associated with it. So whenever there's a claim of retaliation, I think a defense is going to be provided by a carrier. When there is these claims without a retaliation claim included, then I think it's a closer call, and it all depends on the way the allegations are worded and what's the cause of action that they're based on. So if we've got an employment-related practices policy with a breach of written employment contract exclusion, but there would be coverage for a breach of an implied contract, then that would actually have to be pled. It would have to be pled and alleged as a cause of action. And then maybe that would fall within defense coverage. And then the other possibility is if there's a specific allegation that, once the regulatory requirements were enacted, this particular employer adopted particular policies and then negligently failed to follow them, negligently failed to supervise and evaluate them to make sure that they were being carried out. That, depending on the policy language, if that particular definition of Wrongful Employment Act includes the practices and procedures type claim, then that is potentially going to result in a defense being provided. But I think just a regulatory requirements without retaliation and no other sort of cause of action is just not going to even be provided with a defense. On the breach of an employment contract claim, again, that's going to be based on the policy language. So those I would put in sort of a separate category as to whether or not that's going to be provided. You're going to get a defense for your insured or not. There are some that have an overall breach of contract exclusion with an exception for liability you would have had in the absence of the agreement. So even under that circumstance, there would potentially be coverage. So the disclosure of personal health information, most of these policies do have the defamation coverage, right? So you've got coverage for slander and libel, but usually under this circumstance, those wouldn't be invoked. But the last part of that definition is or invasion of privacy. And disclosing someone's COVID status is, I think, going to fall within that. I can't imagine a situation where there would not be a defense provided under that circumstance if that's the policy language in the Wrongful Act definition. On the Families First Pay Act, I would take the position on that I don't know how you would shoehorn that into front pay or back pay. So first of all, there's the exclusion related to compliance with law, but there's also the definition of loss, which just generally is not going to provide an employer coverage for its basic salary obligations to its insured. So if somebody just fails to pay their insured, they're not going to get coverage from their carrier, their employee. They're not going to get coverage from their carrier for the failure to pay wages that are that they've agreed to and that the employee has earned. That's just flat out not covered. And I would take the position that this Families First Pay Act violation, absent a claim of retaliation, that Families First Pay Act violation, I would contend that it likely is not going to fall within the coverage of the policy and or the definition of loss. But I think it would really depend on how that is alleged. In these cases, we talked today about how the early coverage litigation over first party property claims in the COVID cases was maybe not being led off by the specialists that typically do policyholder work. I think in the employment context, when you're looking at underlying plaintiffs' employment lawyers, they really vary in terms of their sophistication level. So if there is a lawsuit brought in the COVID scenario, and it's brought by sort of a notorious employee law firm, right? A law firm that represents employees against employers all the time, represents unions, that kind of a law firm, they're going to know how to design their complaint and the allegations so that they will most likely invoke coverage under an EPL policy because they're going to want that most likely. But I think that in this scenario in COVID, there's going to be a lot less of those. I think it's going to be a wide variety of plaintiffs plaintiffs' lawyers that bring these kinds of cases. So you may not see that sort of very well designed pleading to invoke EPL coverage.
And I would agree with Laura on her final points that we're going to see a wide variety of pleadings, allegations, quality of lawyering on the employee plaintiff side. And that is probably going to have some significant impact on ultimately the coverage issues here. Needless to say, I disagree with a lot of Laura's analysis, but I think what that highlights is there's going to be a lot of tennis playing on these issues as they come up, and there are going to be issues such as: are we just going to try to get a defense? How valuable is that? What kind of impact does that have on trying to settle cases? So again, I think it's very important that folks pay very close attention to the language of the policy. While I think it's true on both sides, again, I reiterate for the policyholder side, if you are as familiar with employment law as you are with coverage law, you're good to go. If not, it would certainly behoove you to coordinate with someone who is, so that you understand all the different positions and arguments that you might be able to make. So we're going to cap this off with a couple of tips, if we could move to the next slide. And the tip that I have is a little bit different than some of the discussions that we've been having, and that is really focused on the future, and in particular on the applications that businesses are filling out for their EPLI coverages. And what I'm about to say over the next minute or so actually applies to just about any application that a business will be submitting to its insurance company. But since Laura and I are talking specific about EPLI, I'll limit it to EPLI. In today's pandemic world, businesses are changing sort of their business models. And some of them may have a material risk to their business that frankly needs to be disclosed to the insurance company. I've certainly had plenty of cases where on executive lines policies where carriers have pointed to the application and said there was some misrepresentation in the application which will preclude coverage. A lot of times those alleged misrepresentations go to the scope of risk that the insurance company says it was intending to underwrite. To give you an example of how the pandemic can change the scope of the risks that your business might face that you might not think about, I'll focus as an example on hotels. Many hotels, particularly in the larger cities throughout the country, have been asked by state and local authorities to prepare their rooms to hold COVID-19 patients when there's an overflow at the hospitals. This could be true for outpatient nursing facilities, which happens to be one that I was personally involved with. in that situation, the addition of COVID-19 patients to your business, I think, is a material term that you really need to be thinking about disclosing in your application, or at least having a discussion with your lawyer and broker. Laura?
Thanks. Just one last point. Reservation of rights letters are critical here, especially when there's a defense. If defense costs are within the definition of loss, that could affect the policy limits, and that carrier's approach to settlement may end up driving the underlying litigation, depending on the insured and how much money they've got. That's all I have.
Thank you.
Thank you, Laura and Chris. So for our last panel, we are coming up now on the 1-year anniversary of the pandemic. And we're going to hear from now from Laura Hartford. I think somebody needs to mute Laura, if you could, please. Thanks. So we're going to hear now from Laura Falgan, who leads the insurance and reinsurance practice at Crowell & Mooring. Laura represents insurers and insurance trade groups in trial and appellate matters across the country, and she's been named a top insurance practitioner in DC and nationally. She's a member of the ACCC Board of Regents and a graduate of the University of Pennsylvania and GW Law School. Importantly for this presentation, Laura's father, John Falgan, was a 1949 graduate of Seton Hall College, and he ran track and was a member of the record-holding mile relay team, which broke the national records at Madison Square Garden and other venues. She is joined in her presentation by David Goodwin, who's a partner in the San Francisco office of Covington and Burling. And David is a policyholder attorney. He's got probably 2 of the pending COVID-19 actions with the largest amount of damages at stake, and he represents in those actions 30 Major League Baseball clubs and the Ross stores. So Laura and David, if you can tell me what lessons we've learned over the last year.
Sure.
Laura, you may need to mute. I think we're getting a lot of feedback.
Yeah. Yes. You want to try one more time, or shall I start? Nope. You're still.
If I might suggest, Laura,
Yeah.
try logging in with an iPhone and let David start with his remarks.
Yeah. Okay. I'll do that while Laura goes to Plan B. So we heard at the beginning of this conversation from Mike Aylward about the 3 phases of plaintiffs who brought the lawsuits. Initially, small businesses represented by small plaintiffs counsel. Then the plaintiffs bar swooped in thinking that they would make a killing on this. And thus far, they haven't done very well. And many of them are pulling out again. And then finally, just recently, lawsuits are beginning to be filed by law firms that have represented policyholders for many years. And this is reflected to some extent in the statistics. As a number of people have mentioned, including starting with Mike Aylward, there is a dramatic difference between state and federal court and between different kinds of insurance policies. My statistics here are a few weeks old, But as of a few weeks ago, insurers have won 97% of federal court cases, and policyholders have won 56% of state court cases, which is pretty dramatic. And I don't know whether it says something about the constituents of the federal bench, given the number of people who were confirmed over the last 4 years, or whether it suggests that state judges are more attuned to what individuals are interested in, or neither. I can't answer that question. But what I can say is that there have been only, I believe, one or possibly two decisions of the several hundred to date that have addressed anything other than an ISO form. And for those of you who aren't aware of what that is, those are the standard forms drafted by the Insurance Services Office and sold to ordinary people, as opposed to the more sophisticated and far more expensive forms that are sold to larger businesses. So we just got a decision maybe 2 weeks ago involving the Cherokee tribes, involving a higher end form, and I believe there may be one other, and there's perhaps a half a dozen to maybe 8 cases involving those forms that are currently pending in the courts. So the decisions in those areas may change how these things play out. Laura, do you want to see whether your audio is improved, whether you've gone to Plan B?
Thank you. I've gone to a headset.
You did it. Good.
Awesome. Hopefully this will help. So I think, David has kind of taken us to the guts of the matter, which is, where are we now, and what is the strategy of the policyholders going forward? And it makes sense that those are the questions that are on the minds of policyholder advocates and maybe on the minds of our attendees as well, because as described, the statistics are pretty impressive in terms of the wins by insurers in the early going. 97% in federal courts is indeed very impressive. And while there may be different percentages in state courts, there have been far fewer cases in state courts. And if you look overall at the statistics, they are still, overwhelmingly in favor of insurers. And they're in favor of insurers on motions to dismiss, like right out of the box at the earliest stage. And one of the things that I would say about, where the litigation has been and where it's headed is that even in the percentage of cases that David and other policyholder advocates are citing, those are instances in which policyholders have survived a motion to dismiss. They're not instances in which policyholders have collected huge judgments of financial loss. And there are many other instances in the course of litigation in which the viability and the appropriateness of the claims are going to be tested. So I think that there's a little bit of a fallacy in even suggesting that there are wins right now other than insurer wins, because many of those cases where insurers prevailed on motions to dismiss are final orders, literally dismissing the litigation. And even in the minority of cases where courts have permitted in some instances policyholders to appeal, we have instances of policyholders to, amend. We have many instances in which policyholders chose not to, because there's nothing more to be said to round out their claims or their litigation, and instead have chosen to appeal. So the question, how have insurers responded? They've responded resoundingly with motions to dismiss, and they've been very successful in doing so. And I think that really fundamentally reflects the insurer's view and understanding by and large of what these policies do. And unless higher end policies are fundamentally different from other insurance policies, the kinds of policies that courts have been grappling with to date, these are property policies that are designed to address property losses, physical buildings and physical contents. They're not operations policies that are designed to ensure policyholder operations. So that's kind of the guts of where insurers have grappled with the early cases. David, I'll put it back to you.
Okay, sure. So much of what Laura says, I do agree with, that most of the cases to date have found for insurers. At least the Cherokee Nation case was a summary judgment for the policyholder on a higher end policy, and we'll have to see. But there really are significant differences between the ISO forms and some of the other forms. But where are we heading, which is the more interesting thing. The insurance industry strategy, and I'm assuming that it's been coordinated because it can't be otherwise, has been to try to get favorable law for insurers by doing several things, one of which is picking out weak policyholders to move against, hiring very high-end law firms to handle them. I mean, when you see a case with a mom and pop restaurant and Gibson, Dunn and Crutcher or Simpson Thatcher or equivalent law firms are on the other side, you know that this is not because the insurer is paying top dollar because they're worried about a final judgment of $100 million. They're doing this to create good law. And what they want to do is they would like to get on zero record, just on the language of the policy and on an inadequate pleading, in front of a highest state Supreme Court and start getting appellate law on this. And that's understandable, and that's probably what I would do in their shoes. And obviously what the policyholder strategy is to try to get a record together. What does the virus do? Does it cause physical loss or damage or not? Which is a factual issue, which is going to turn ultimately on expert testimony. And the issue is this going to be decided in the abstract, or is this going to be decided on a record? And that certainly remains to be discovered. We will find out how this is going to end up. The kind of as a final point, there are a number of appeals pending right now. I think 34 appeals are pending, mostly in the Third and Ninth Circuit, a few in state court. And the issue is going to be whether these courts are actually going to decide the appeals, or the federal courts are going to punt them to the state courts, and whether the state courts are going to want to take them with an inadequate record. And so that's going to be something that's going to be coming up over the next 60 days, I think, as we're going to hear more about that. So back to you, Laura.
Thanks, David. And I think we will hear more about the appeals in the coming days, because suddenly we are seeing an increasing number of cases go up on appeal. And of course, I would say that those appeals are appropriately going up on motions to dismiss, where there are fundamentally legal questions about what these policies cover and don't cover. And in many instances, the courts have said quite clearly that even with the kinds of allegations that David has described, we are not talking about something that the policies are designed to address. I mean, courts have been very clear in saying, they're sympathetic to the plight of business owners in the wake of the COVID-19 pandemic. And this is quoting from one of the courts. Yet the court cannot allow sympathy to cloud its review of the plain meaning of an insurance policy. Insurance companies cannot bear the burden of a crisis where, as in that case, the policy does not provide coverage for purely economic losses resulting from the pandemic. And that's really the question. Is it a legal question about the application of the policy language? And does the policy language, squarely exclude this type of loss? From the insurer's perspective, the answer is certainly yes. And that's also a common sense answer. And one of the things that we've seen, and we haven't gotten into, although David's question asked about the plaintiff bar strategy and the policyholder bar strategy. One of the things we have heard much of in the press is this idea that insurers are holding, $800 billion in surplus that businesses desperately need because of the substantial problems that have been caused for many small businesses as well as larger businesses in the pandemic. And while there's no question that there have been many operational losses as a result of the pandemic, that insurance surplus is set aside for business policyholders for all types of future claims, for fires, storms, vehicle collisions, other losses that occur daily throughout the country. And when you look at the size of COVID losses in comparison, there is an analysis that was done by the American Property Casualty Insurance Association in May 2020 that estimated that if you allowed courts to construe policies, notwithstanding their clear terms, to afford coverage and force insurers to pay coverage for business interruption losses, just looking at businesses with fewer than 250 employees and some business interruption coverage, the estimated losses would be between 86 billion and 317 billion monthly. So we're not talking about insurers just holding a pot of gold that will solve the nation's economic problems. And I think, that's going to be put to the test in the appeals.
I will conclude just by saying there really is a significant difference between the ISO form and other forms. Other forms, for example, have express coverage for communicable disease, which you don't see in the ISO form. But one of the most interesting developments, and I will close with this, is what happened in England, where the Financial Controls Authority, which is their equivalent of the Department of Insurance, just filed a lawsuit against a whole bunch of insurers and said, we don't have a claim, but we want the courts to tell us what the insurance policies mean. And from the date of filing to the date of a decision by the Supreme Court of the United Kingdom was roughly 8 months. And we then got an opinion from the UK Supreme Court that if you added up the pages, they're something like 1,000 pages long, addressing all of the issues under English law. The policies are very different from American policies, but it would be fascinating if someone did something like that in the US, right?
And David, I'll just say thank you for your comment that the policies in the Financial Conduct Authority test case were very different. They indeed were, and I think it's important for people to understand. Laura Hansen mentioned earlier, we always hear read the language of the policy, and I guess you're urging that in some respects in your comments as well. But in the FCA case, those were policies that did differ very, very fundamentally. And in fact, the Financial Conduct Authority in the UK specifically stated that it agreed that policies that were tied to physical loss or damage did not afford coverage. And instead, it took a group of policies that afforded different kinds of coverage in its test case, took those policies forward. And they were very, very different from what we're seeing, in most of the US cases. So we will see. We've got a number of cases that have gone up on appeal. We have cases on appeal in the 8th Circuit, in the 9th Circuit, in the 3rd Circuit. We have cases on appeal in state courts in Ohio and state courts in North Carolina. And the numbers and the appeals are growing. So in another 6 months or another year, we'll have a lot more to report about where the courts are and whether there has been any change in the overwhelming sense to date that insurers properly have denied claims where policies are tied to direct physical loss or damage.
Well, thank you, Laura, and thank you, David. And thank you to Seton Hall for your partnership and support, and to all our American College speakers. But thank you as well to all of our participants who were able to join us today for your interest and your attention. We hope this was a helpful program to you. Be well all.